Welcome back, great people. So remember, we are doing an analysis of the civil procedure rules, and we had successfully completed the analysis of order 1, rule 1, all the way to rule 15 thereabout. We were to begin on order 2, but this time we are doing a marathon because remember, time is of the essence, and we must understand every order by order before rushing, in as much as we want to rush. So it is a balancing act that I'll be playing before you. So follow keenly and with speed. So I want to start from order 2. All that was discussed in our previous session 1. You can go back and listen to the recording. It is available. The same was well detailed. So basically, we will begin with order 2, and order 2 talks about pleadings generally. Okay. And there are some key takeaways that I highlighted in this part. The one that I've highlighted in red. Order 2, Rule 4, for instance, is an enforcement clause in that whenever you want to plead any matter, for example, on performance, release, payment, fraud, inevitable accident, act of God, or any relevant statute of limitation, or any fact showing illegality, you must plead with specificity. Okay. Because if you read that Rule 4.2 on recovery of land, it says that in suits for recovery of land, the defendant must plead every ground of defense specifically, because I am in possession alone of that land will not be sufficient. You have to attach relevant documentation to show that you are the actual person in occupation of that land. Okay. So basically, that was a good analysis from my end. But now you can be told to attack a plaintiff that has not disclosed those requirements. Okay, and now you have to draft a notice of motion application seeking for further and better particulars pursuant to order 2, Rule 10. So order 2, Rule 10 has allowed a defendant, has given the defendant the chance. We'll arrive at Rule 10. It has given the defendant a chance to attack your plaint or documents or pleadings, because the enabling provision is order 2, Rule 10. And the price that you'll be seeking is as follows: that the plaintiff be ordered to supply further and better particulars of the allegations of fraud, illegality, misrepresentation in paragraph this and this, including the specific acts or omissions being alleged, the person alleged to have committed them, date and place and documents relied on, and the manner in which the defendant is said to be implicated. So just know that there is this kind of an application to be done. Okay. What are some of the particulars in defamation actions pursuant to Order 2, Rule 7? So Order 2, Rule 7 is a pleading discipline rule for defamation, because if you rely on an innuendo or secondary defamation, meaning you have to show justification plus a fair comment or express malice to defeat privilege or fair comment, and you must plead the required particulars, otherwise you risk being shut out at trial or having the pleading struck out. So that is specifically what you have to prove for defamation cases. And maybe the examiner can decide to test you to see whether you understand what form part of the particulars for you to say that a certain word is a defamatory in nature or it is an innuendo. And the examiner will be interested in the following words. Were the words understood by readers or listeners to mean, indeed mean, that the plaintiff is a thief, is corrupt, or engaged in bribery? Okay. Was the plaintiff in a position or role? Was he in an institution, and was he publicly associated with a certain event? Is the fact linking the description to the plaintiff? And is the fact showing criminal or ethical connotation? Okay, so those are the things that you as the student will be expected to draft whenever you have been told to draft an application on your feet, and this application appears to be emanating from a defamatory framework. There is also an expectation of from you that you understand what forms particulars of justification of truth in unfair comment. Okay. So those are the nitty-gritties. Then we have particulars of pleading, Order 2 Rule 10. This is where we have seen there is an application that you can make to request for particulars and various documentations to justify. I've had there is a text. Let me see. Okay. So we have Order 2 Rule 11 on admissions and denials. Now we have started narrowing down. Okay. Order 2 Rule 10 is enforced to prevent trial by ambush. If you plead fraud or misrepresentation or undue influence or breach of trust, you must set out the material facts and specific facts. If you don't, the court will usually order particulars or allow amendment, but can strike out in persistent or serious cases. So Order 2 Rule 11 provides for a general denial or non-admission is not a proper traverse, because untraversed facts are deemed unadmitted and can support judgment on admission. Every pleading must contain necessary particulars, including particulars of fraud. Admissions and denials must be specific. Any allegation of facts not traversed is deemed and admitted. A traverse may be denial or non-admission, but general denials are insufficient. You must specifically traverse each factual allegation you don't admit. This is the reason why when you are doing a reply, when you are doing a defense to a plaint, you have to categorically say, in response to paragraph 1, the defendant traverses and denies in total for the following reasons. You list them. Mere denials will not suffice to merit your defense. In fact, the plaintiff can apply for the summary dismissal of your defense because your defense does not raise triable issues. Okay. Those are the nitty-gritties that you must understand at your fingertip. And there is an application that you can make called Form 2. Okay. This form is a notice for particulars. This is where the defendant or plaintiff requires the other party to give particulars of a certain matter. Okay. So this is allowed pursuant to Order 2 Rule 11. Okay, we can confirm Order 2 Rule 10. Sorry, Order 2 Rule 10. This is a form that has been provided directly by Order 2 Rule 10, and in particular, if you read at 10.5. No order for cause shall be made in favor of a party applying for an order who has not first applied by notice in Form 2 of Appendix, which shall be served in duplicate. So form 2 is the one that I have drafted here under. It is a notice for particulars, where you have to request for particulars first before you can be awarded cost. And this should be served. This notice for particulars should be served upon the plaintiff or the defendant. Then this is how you will structure your application for further and better particulars. Person to order 10, order 2, rule 10, 2 to 6. This is to be used after serving form number 2. Okay, so you serve form number 2. So this is where the examiner will test you. You've been told that a plaintiff has decided to file a plaint, and this plaint has not confirmed with, complied with the particulars required on fraud or misrepresentation, and now the examiner expects you as the defendant or an advocate acting on behalf of the defendant to do an application requesting for particulars, then seek for cost or termination or the matter to be struck out. So this is what the examiner will expect. The examiner will expect to see that you have drafted form number 2, that you duly serve this form number 2 on notice for particulars. You are requesting for particulars. Okay. If the same is ignored or it is insufficient, then move the court by drafting an application for further and better particulars under order 2, rule 10. Okay. After serving form number 2. And this is how it will appear. That you are requesting for full particulars of alleged fraud, particulars of alleged knowledge, and particulars of facts supporting the alleged state of mind. You have said there is malice. What are the grounds? You will list the grounds pursuant to the required standards. Okay. The pleadings allege fraud, but it is not particularized pursuant to order 2, rule 10. And the lack of particulars prejudices the applicant's ability to plead and provide its case. And the applicant has served a notice for particulars in form number 2. So if the examiner will see that you have duly complied with serving form number 2, then you will be granted the necessary orders by court. Okay. Denial by joinder of issue. Courts usually treat order 2, rule 12 as a default denial mechanism. If you don't file a reply to defense, the law deems you have joint issue, meaning you deny the defense material facts, but you still cannot use silence to introduce new facts, and you cannot join issue against a plaint or counterclaim. You must file a defense or a defense to counterclaim. What am I saying? If there is no reply to defense, there is joinder of issue on that defense. A joinder of issue operates as a denial of every material allegation of facts in the pleading joined to unless expressly admitted in an express joinder. Pleadings usually close 14 days after service of a reply or defense to counterclaim, if none is served 14 days after service of defense. Okay? Failure to file a reply does not mean the defense facts are admitted. It triggers joinder of issue and the defense facts remain to be proved at trial. Okay? So I can explain from the practice element. Once the plaintiff has filed a plaint, the defendant will file a defense. Then the plaintiff still has the right to do a reply to the statement of defense that has been filed by the defendant. So what order 2, rule 12 is telling us, it's saying that if the plaintiff has not replied to the statement of defense, it is not to mean that the defense facts are admitted. Okay? It only triggers a joinder of issue and the defense facts will remain to be proved at trial. So you agree with the defendant that these are the issues that the court is to determine. So that is the practical element of looking at it. Okay? So how will you do a reply to defense? As we said earlier, you do a reply to defense countering each and every paragraph. Where you admit, you say you admit. At times, you could have missed the 14 days duration. You do an application to seek leave to file a reply or a defense out of time where pleadings have closed. This will be a catch where many students will avoid the angle of seeking extension of time where close of pleadings has occurred. Failure to file a reply does not amount to admission. There is a joinder of issue operating as denial under Order 2 Rule 12. Close of pleadings, Order 2 Rule 13. Order 2 Rule 13 now is applied strictly as a bright line timetable. Pleadings close automatically 14 days after service of the reply and defense to counterclaim, or if none is served 14 days after service of the defense, and a pending request or order for particulars does not stop that clock. So there are some nitty-gritties that you have to understand. Only one amendment without leave is allowed before pleadings close. After closure, you need a leave. When the examiner tells you to amend a certain application or pleading, and you have categorically been given dates, and these dates are way beyond 14 days, or you have been told that a defense has been filed and 14 days has lapsed, okay, after service of that defense or a reply, okay, you will first seek leave for you to do an amendment where pleadings have closed. But you don't need leave to do one amendment where pleadings have not closed. What order will you use when you want to move court for extension of time to file a defense or reply? You move court pursuant to Order 50 Rule 6, Order 7 Rule 17, Order 2 Rule 13, Order 51 Rule 1. Those are the nitty-gritties. Striking out pleadings, very important, very important. At any stage of the proceedings, the court may order to be struck out or amended by any pleading on the ground that 1. It discloses no reasonable cause of action or defense in law, or B. It is scandalous, frivolous, or vexatious. C. It may prejudice, embarrass, or delay the fair trial of the action, or D. It is otherwise an abuse of the process of the court. It may order the suit to be stayed or dismissed, or order to be entered accordingly as the case may be. Okay. So far as applicable, this rule shall apply to an originating summons and a petition. They will not be spared. So many students usually break down point number B, in that they say that this court should strike out this pleading for being scandalous, frivolous, and vexatious, and they expect 3 marks. That is erroneous. You have to list the 4 and you expect 4 marks or 3 marks. No cause of action, scandalous, frivolous, vexatious, 1 mark. It may prejudice or embarrass or delay the fair trial of the action, and it is otherwise an abuse of the court process. Abuse, embarrass, scandalous, cause of action, no cause of action. It is treated and interpreted as the last resort because it is draconian. Now, the examiner will tell you, you are acting on behalf of a defendant. Kindly move the court accordingly to strike out a plaint that is scandalous, frivolous, abuse of the court process, and may embarrass the plaintiff, may embarrass your client being the defendant. So you move court through Order 2, Rule 15, and Order 1, Order 51, Rule 1, via a notice of motion. Okay? And in this application, you'll be saying that the plaintiff be struck out for disclosing no reasonable cause of action. It be dismissed with cause. What are the grounds? Now you list the grounds pursuant to the test applicable for you to be granted orders in this application. Okay. Then we go to Order 3. For Order 3, I'm looking for joinder of causes of action, Order 3, Rule 5. So courts generally interpret Order 3, Rule 5 as a permissible joinder rule. You can combine multiple causes of action in one plaint against the same defendants or jointly against defendants. And misjoined objections usually fail unless the joinder makes the matter unmanageable. Then the court orders separate trials rather than striking out. Okay. A plaintiff may unite several causes of action against the same defendants, or multiple plaintiffs may unite causes of action in which they are jointly interested against the same defendants. That is allowed. Pursuant to Order 3, Rule 5. Joinder of causes of action can lead to joining of the different parties. Then there is an application to amend plaint to join additional causes of action. So this is how you do an application to amend plaint, where you have realized that your plaint has not disclosed a reasonable cause of action, and you know that failure to disclose a reasonable cause of action can render your plaint being struck out. Okay, can render your pleadings being struck out pursuant to Order 2. Order 3, Rule 6 is interpreted strictly in a suit where primary relief is recovery or possession of immovable property. You cannot bundle unrelated claims unless they fall within the listed exceptions or you first obtain the court's leave. So in general, so that you understand, in a suit for recovery of immovable property, no other cause of action may be joined except with leave unless it is about mean profits, damages for breach of the contract under which the property is held, damages for wrong or injury to the premises, and claims where relief is based on the same cause of action. So if the extra claim is incidental to the land dispute, where we can say there is possession and occupation, courts allow it to proceed. The usual package is possession plus injunction plus mean profits and trespass damages. Okay. Then you can also be told to do an application seeking leave to join additional causes of action in a land recovery suit. This is how it will appear. You cite the reasons why you want to introduce the new causes of action. You list the causes of action. Then Order 4 on plaint. What are the various particulars of a plaint? This is where the examiner will tell you to draft a plaint or necessary documents and give you 10 marks. So you should know that the plaint shall, it is mandatory, shall contain the following particulars: the name of the court in which the suit is brought, the name, description, and place of residence of the plaintiff, and an address for service, the name, description, and place of residence of the defendant so far as they can be ascertained, the place where the cause of action arose, Where the plaintiff or defendant is a minor or persons of a sound mind, a statement to that effect, and an averment that there is no other pending suit, and there have been no previous proceedings in any court between the plaintiff and the defendant over the same subject matter, and the cause of action relates to the plaintiff named in the plaint. Then a plaint shall be accompanied by an affidavit sworn by the plaintiff verifying the correctness of the averments contained in Rule 1(1)(f) above. Where there are several plaintiffs, one of them, with written authority filed with the verifying affidavit, may swear the verifying affidavit on behalf of the others. The plaintiff is a corporation, the verifying affidavit shall be sworn by an officer of the court duly authorized under the seal of the company to do so. That was very important for us to analyze and know what a company is a plaint, what is mandatory in a plaint. Then order 5 about service. Service is very essential, and I've highlighted the same. If you are serving a corporation, a company, order 5 rule 3, subject to any other written law where the suit is against a corporation, the summons may be served 1 on the secretary, director, or other principal officer of the corporation, or if the process server is unable to find any of the officers of the corporation mentioned in Rule 3A above, by leaving it at the registered office of the corporation. B. By sending it by prepaid registered post or by a licensed courier service provider approved by the court to the registered postal address of the corporation, or if there is no registered office and no registered office or physical address of the corporation, by leaving it at the place where the corporation carries on business, or by sending it by registered post to the last known postal address of the corporation. Those are the various rules required for service on a corporation. Pass on to order 5 rule 3, very important. Then you can be told to do a service outside Kenya. Many students will find challenges in this part because they have not read this part. So service out of Kenya is provided under Order 5 Rule 21. And service out of Kenya of a summons or notice of a summons may be allowed by the court whenever those happens. So those are the various categories of situations where you will be forced to serve outside Kenya. So you can only serve summons outside Kenya with the court's leave, and only if your case fits one of the gateways under Order 5 Rule 21. Okay. If you skip leave or use the wrong mode, e.g. if a local newspaper advert for a foreign resident defendant, service will be irregular and any default steps will be vulnerable to being set aside and struck out. So generally, so that we understand the various gateways for leave, pursuant to Rule 21, the court may allow service out of Kenya where, among others, the suit concerns Kenyan immovable property, instruments affecting Kenyan immovable property, relief against a person domicile or ordinary resident in Kenya, administration of estate or trust to be executed per Kenyan law, contracts with specified Kenyan connections, and Kenyan, then we have lastly a tort committed in Kenya, or a breach or injunction or nuisance concerning acts in Kenya, and where a person out of Kenya is a necessary party. Those are the various situations that you should expect from the examiner in an examination setup. Then we have taken a note that we must seek leave from the court for us to effect service upon a person outside Kenya. How will you approach court for this application? This is how it appears. You approach court through Order 5, Rule 21, Order 51, Rule 1, then Section 1A, 1B, and 3A of the Civil Procedure Act. So you detail your application and that the suit fails within Order 5 Rule 21 because you explain yourself why this is sufficient. You are seeking an injunction for act done in Kenya. Necessary party, the tort has been committed in Kenya. The contract or breach is governed by Kenyan law. Subject matter is involved property in Kenya. Those are the things that the examiner will be looking at. Will be looking to see, do you really understand that? Then there is an amendment that was introduced in internationally registered and recognized courier services. So summons may be sent to the defendant by way of registered courier service provider, okay? And this service shall be effected only with the leave of court through an internationally registered and recognized courier service provider to the defendant's last known physical address. So that will be allowed to also be served upon a person outside the jurisdiction of the Kenyan territory. Then we have electronic mail services, emails. Summons sent by emails shall be sent to the defendant's last confirmed and used email address. Okay, and service shall be deemed to have been effected when the sender receives a delivery receipts. So there are some developing jurisprudence that says that you must attach a delivery receipt when you are using emails. And then we also saw another amendment to these rules pursuant to legal notice number 22 of 2020 that said mobile enabled messaging applications, where summons may be sent by mobile enabled messaging application to the defendant's last known and used telephone number. Okay, so that has recognized the day-to-day running of technology and developments in the same sector. So at least it has appreciated the same. So I cannot skip order 7. I cannot skip order 7 because order 7 reveals about defense and counterclaim, and it is important we extract various oral questions that can emanate from that part before we go to order 8 on amendment of pleadings. And it is very vital for us to read verbatim what the act defines a defense, a set of, and a counterclaim to be. Then we move downwards to order 8. So generally, a defense is provided under Order 7 Rule 1. So where a defendant has been served with a summons to appear, he shall, unless some other or further order be made with court, file his defense within 14 days, after which he has entered an appearance in the suit and serve it on the plaintiff within 14 days from the date of filing the defense and file an affidavit of service. Then, this is where the catch is: set off versus counterclaim. A defendant in a suit may set off or set up by way of counterclaim against the claim of the plaintiff any right or claim, whether such set off or counterclaim sound in damages or not, and whether it is for a liquidated or unliquidated amount. So set off is where the other party also has a debt. So you want to set off, you want for the amount to be less so that you can have a balance that you are intending to clear off. Okay. Then you do a counterclaim. A counterclaim is a separate suit on its own, and it can survive even if your main suit failed. So a counterclaim is like I'm also suing you for a different cause of action, separate from what you have filed against me. That's why it will survive. So generally that is what I wanted to bring out clearly. Then we finish with order 8 and look whether we can see another technical part before we jump into other acts of parliament. So order 8 is very vital for us to understand, because amendment once without leave before close of pleadings is provided under order 8 rule 1. Then we said that after 14 days an opposing party may apply within the 14 days first of service to disallow an amendment made under rule 1.1. If the court is satisfied leave will have been refused under rule 3, it must strike out the amendment. Then amend with leave at any stage on just terms, then correcting because leave may be granted for correcting a name, altering capacity, adding or substituting a cause of action arising from the same or substantially same fact, and general power to amend documents to determine the real controversy and correct an error, If leave is granted, amend within time. Amendment without leave is only valid before clinics close. So basically, those are the various rules that I wanted you to understand. How do you seek leave to amend? So this is how you will approach court order 8 rule 3. You will approach court through a notice of motion. You will be telling court that you intend to amend your plaint or document. Then take note on the grounds being relied upon that you're telling the court that the amendment is necessary to enable the court determine the real question in controversy. The amendment arises from the same or substantially the same facts already pleaded, and no prejudice will be occasioned that cannot be compensated by cost. So those are the languages. Those are the language. That is the language that the examiner will be expecting to hear from you. You can also attack where a leave has not been obtained. So when we'll be resuming back, we will go back. Now we will begin exactly from order 10, and we will finish from order 10 all the way to the next order that I will have realized that, okay, we have now done the substantive part when it comes to civil litigation, because I realized that for civil litigation, we are dragging far behind because we have still not yet exhausted to the substantive parts because the syllabus is really moving fast and quickly. So we should not be left behind. We should move with speed and accuracy and in a bid to understand. In fact, if we just understand the civil procedure and it be at our fingertips, then automatically we will have an A, a straight A in civil litigation papers. Okay, that was my intention. So you hold on your horses as we begin from order 10, because there are some vital applications that emanate from this act, similarly to the criminal litigation one that we are jumping over. So hold on, we must do a substantive application for each. So don't panic. Don't panic. Thank you so much.